Hello, so this lecture will be an introduction to civil procedures, otherwise known as litigation, for land surveyors. So I call it an introduction just because you can make a whole class over how a surveyor is involved in court and the various types of cases that a surveyor may become involved in. So start off with some generalities, some terminology. The court system is divided into two separate parts, two different philosophies, two different legal approaches. Those two are civil and criminal. Of course, that makes common sense. Criminal cases are prosecuted by district attorneys, attorney generals, solicitors, solicitor generals. In other words, the government is the moving party, the one who brings the suit. Never does an accused person bring a suit. It's always the state versus the defendant. Criminal procedures act with the presumption of innocent until proven guilty, and with the presumed recognition that someone's liberties and even their life is at stake. So the threshold for guilt is pretty high for a conviction in the criminal court system. It requires a determination of guilt beyond a reasonable doubt by the jury. Most all criminal cases are jury trials. Civil cases, however, they don't require that high of a threshold. Instead, civil cases should be decided on a preponderance of the evidence, or in other words, what decision or what outcome or what position is more likely than not. So you can even boil that down and say 51%, because in a criminal case, if you're not positive beyond a reasonable doubt, you rule the person's not guilty. They are innocent by default, or innocent until proven guilty. But in a civil case, you got to have a winner and a loser. You can't just say, well, I don't know, or, tie goes to the runner, or we'll just give the defendant, the benefit of the doubt. You got to have a winner and you got to have a loser in a civil case. So even if it's just 51-49, somebody comes out on top. And that can come out from being outlawyered or having a better case. I've seen it both ways. Civil court has a totally different set of rules, because nobody's going to be imprisoned by civil court. Nobody's going to be given the death penalty. Nobody's going to lose any of their civil liberties or their constitutional rights in a civil court. So they're set up totally different. Federal courts adhere to a published book that applies in all federal courts called the Rules of Civil Procedure, the Federal Rules, the FRCRs. States have their own rules, and sometimes these can be in court documents, sometimes they can be in the state law, sometimes they can be in the handbook by the Supreme Court. But basically, each court system has its own set of rules. So, where and how do land surveyors fit in? So, surveyors are obviously generally involved in civil cases, although we could be witnesses at a murder where somebody shoots another property owner or something. Thankfully, even mentions of those sort of things are rare. We're generally involved in civil lawsuits, in civil cases. So civil lawsuits generally begin as disagreements. Simply, I think the line's over there. No, I think the line's over there. Or, I think you're trespassing. I think I've got an easement that allows me to trespass. I think those are my trees you just cut. No, they're on my side of the property line. And of course, these are very simplistic. But these disagreements come up when they can't be settled. Either, somebody goes, the heck with it. You can have those trees. I'm not interested in fighting about it. Well, in that case, a lawsuit does not come forth. But if both sides feel like it's necessary to have the matter settled, to get to the bottom of it, and if they can't agree, then lawsuits typically are what comes up. The traditional lawsuit that land surveyors are typically associated with are boundary disputes. Where is the property line? Maybe surveyor 1 says it's over here, surveyor 2 says it's over here. Neither side can agree. They wind up in court. I've been involved in a lot of cases. Other types of cases that I've been involved with are quiet title actions, which may involve title issues, not just boundary locations. Easement rights. Does someone have an easement here or is it over there? And what does that easement right involve? It can be over setbacks or covenants, like he built his house too close to my line. It's damaged my privacy. Drainage impacts. She built a house right here and all this runoff is going into my garden or going into my driveway or going into my house. And then there's professional negligence. I've been involved in several cases against land surveyors where they're being sought damages because of professional negligence, where surveyors have done a bad thing or been accused. I've been on both sides. I'm not strictly one who helps lawyers and people go after negligent surveyors. I have assisted a couple of surveyors that were sued when they really shouldn't have been, when they were not negligent. So some more basic terminology: the party who brings the lawsuit is the plaintiff, the party who's being sued is the defendant. And some cases can have multiple plaintiffs, like a class action lawsuit, or multiple defendants, like everyone in a certain subdivision or everybody that lives on a certain road. All right, so the court system is backlogged and overloaded. It takes years for a case to go through. The average, in my experience, from the time they file a suit till the time it's actually done is around 5 years. I saw them go as long as 7 or 9 years, and I have heard of one going as long as 13 years. Criminal cases get the priority over civil cases because society determines that criminals need to be brought to justice. Justice must be done, and the accused, their life is on hold until the case is over. If they're innocent, they need to be proven innocent and turned loose. They're being held, or they're out on bond or with an ankle monitor or whatever. So they have to prioritize criminal cases. And if we were charged with a criminal case, or if we had a family member who had been a victim of a crime, we would want the criminal cases prioritized. So that's just a fact of life. So especially more so than criminal cases, civil cases are supposed to be mindful of judicial economy. In other words, use the court's resources sparingly. Courts have taken a very dim view on frivolous lawsuits and on attorneys who drag cases out and tie up the court's time. Courts often have some procedural rules that require alternate dispute resolution, ADR, which is mediation and arbitration, where you sit down with a mediator who tries to play referee and tries to help you come to a settlement agreement. Most courts have that as mandatory before you ever get too far into it. Before you ever take up the court's time with a hearing or a trial, they're going to require that you sit down and have mandatory mediation. So they're just trying to minimize the amount of time that the court has to spend on these cases. So when this disagreement has gone as far as it can and people are not, they're not coming to agreement, it's still unresolved, hostilities still exist, diplomacy is failing, and warfare is imminent. The first thing that usually happens is whichever party decides to first or gets to first or is the most ambitious, they will have a demand letter sent to the other side. So if it's you and your neighbor, you hire an attorney, they send a demand letter to your neighbor. Or maybe your neighbor gets their attorney and sends you a demand letter. So, the attorney for the party, they'll lay out the basics of their client's position and what they are demanding. For example, they might say, "Dear Mr. Doe, my client, Mr. Smith, believes that you are trespassing onto his property and cutting down his trees. We demand that you immediately cease this trespass and reimburse Mr. Smith for the value of his trees, or we will have no choice but to pursue this matter in court. So, that's firing the first shot, firing a shot across the bow, staking out your claim, however you want to put it. Sometimes these demand letters are bluffs because they don't really want to go to court, but they want to threaten to. Kind of like, blowing up fists and saying, all right, I'm going to beat you up if you don't take it back. If they don't take it back, maybe you don't want to fight that bad. The demand letter also fills a purpose in the whole process of litigation, in that it demonstrates that the moving party, the plaintiff, the one who starts it, they tried to resolve the situation reasonably instead of just firing off a lawsuit and clogging up the court system. The demand letter usually lays the groundwork for the forthcoming lawsuit. It might say you're in violation of Georgia Code section such and such. It says you cannot trespass on my land. It says that an easement can't be used for this, blah, blah, blah. So the demand letters are usually very carefully crafted, and they're very factual, so that they don't leave out any pertinent aspects of the situation, because if they send a demand letter about don't cut down my neighbor's trees, then the lawsuit says don't cut down my neighbor's trees, quit using the driveway by the mailbox, don't shoot your guns after 7 o'clock at night, quit yelling at my client and calling him bad names. Well, all that should have been in the demand letter. The court will basically look at a demand letter as, well, they tried in good faith to resolve all this. It didn't work. Otherwise, you're being stubbornly litigious, and the court looks at that very bad. Now, one thing that I want to stop and interject right here is that once a side has an attorney, that attorney is supposed to be the spokesperson for that party. If that's your client who has an attorney, you can still talk to your client. But as far as if the other side has an attorney and they want to talk to you about why you did something, you're supposed to direct them to your client or your client's attorney. Most communications then become funneled like an hourglass through the attorneys. The plaintiff's attorney can't talk to the defendant. They have to talk to the defendant's attorney. So this is why, if you've seen this in the business world where people say, no, we can't talk, we've got attorneys. Once attorneys have been engaged to represent someone, they must be used to represent them. You can't go around the attorneys. Once an attorney is engaged, the attorney is the spokesperson. So you got to be mindful of that. So once you've got the demand letter, you're on notice that the plaintiff, the person, or the potential plaintiff, the person whose attorney has wrote a letter, you can't just go to Mr. Smith in this situation. If you're working for John Doe and Mr. Smith hires an attorney who fires off a demand letter, you're not just supposed to have any contact with Mr. Smith anymore. If it's getting litigious, all of your questions are supposed to go through Mr. Smith's attorney, and that way they keep track of what's going on, etc., etc. So here's a sample demand letter. This is an actual demand letter that was served upon a surveyor by a title insurance company. And basically what it says is, here's where this came from. The title insurance company to a surveyor who I will simply refer to as associates. So I'm protecting their identity, not trying to embarrass this particular surveyor. What happened here was this surveyor surveyed a couple of acreage pieces joined each other. He surveyed one of them. A couple acres in Cobb County might have 10 houses and a street on it. In the rural area like Fannin County, a couple of acres out of a 25-acre piece, that's noticeable, but it's not the whole kit and caboodle. So associates surveyed this piece of property, and they hired associates to survey it. Associates sent a crew out there. The legal description required attention to detail. They did not go in the right direction when they got to a certain point in the legal description, and so they incorrectly surveyed their boundary over onto my client's property, who was not my client at the time. Roberta, my client, went to them and said, hey, I think you're wrong. My boundary's over here. My deed says this. Associates didn't go along with it, said, no, we're right. We're staying put. We're not going to change anything. We've got it right. You're just mistaken. Roberta hired my firm to come out and survey her property. And we don't always agree with the client. We'll tell them, if we can't defend our work and it's not what you want, then maybe we're not the surveyor for you. But in this case, we went out, we determined that she was in fact correct, that associates did overlap and come over on her property, basically trespassed. And it came to 2.19 acres that associates had aired and surveyed some of Roberta's property. So associate's client, Norman, had title insurance. So he went to his title insurance company and says, hey, Roberta has filed this lawsuit against me, against 2.19 acres, and saying that it's hers and not mine. So the title insurance company got involved. They hired their own counsel, even though they have lawyers that are on staff. They hired outside counsel to review it, looked at it and determined, oh yeah, wow, associates really went outside the reservation. They overlapped Roberta. We need to shut this down right now, because if this goes to court, we will lose and it will cost a lot more money, and we might even have to pay court costs. So the title insurance company made a business decision that they would try to settle it, and they paid Norman off $55,000 for his 2 acres. And they determined that it cost them $20,348 to investigate and get involved in this claim. So they sent a letter to associates demanding that they remit a check within 10 days for $75,348 to the title insurance company, or they may take additional actions to recover the loss, including but not limited to filing a lawsuit seeking all potential damages. So don't be getting a demand letter, but that is a demand letter. It says, hey, we think you've done this. Here's the facts. Here's what we think you owe us, what needs to happen. And you need to pay us, or we're going to file a lawsuit. It's basically what it is. Now, most real estate attorneys, this is who us surveyors wind up dealing with a lot, right? Real estate attorneys. We deal with real estate attorneys. Well, actually, they're usually transactional attorneys. Real estate attorneys can mean basically 3 different kinds: transactional attorneys, title attorneys, and litigators. So they all have the same degree, a Juris Doctorate or a Doctor of Jurisprudence. They all pass the same bar exam, but like doctors, they specialize. And most of the attorneys that surveyors work with are real estate attorneys, which are transactional attorneys. A transactional attorney is often called a closing attorney, and they specialize in closing transactions. Closing means it's done and you close the books. Everybody signed everything, all the money's changed hands. We're closing the deal. So they are closing attorneys. It might be buying and selling a new home, a piece of property, a building, might be doing a new loan or a mortgage or a refinance. Some transactional attorneys also will write sales contracts. Sales contracts are usually more specifically and legally called a purchase and sale agreement, or a PSA. You'll often hear, if you're working for a buyer or a seller, I'll send you the PSA. That's got all the terms of what they're selling, what goes with it, how much they're paying for it, when they're closing it, what issues they know about, etc. Now, the standard residential real estate contract is just boilerplate language that is commonly used in a residential transaction between two people that's pretty low key. But if it's a $4 million office building, they're probably going to do a PSA that spells out a lot of details, assignment of rents, liabilities, lease terms of existing tenants, blah, blah, blah. So some real estate attorneys also represent strictly one side of a transaction. Such as the seller's counsel or the buyer's counsel. The lender often has their own attorney whose their job is to look out for the lender's best interest. They're the ones that will nitpick an ALTA survey to death because they don't have anything to lose. And or their job is to make sure that everything's right and that the lender is particularly protected. The larger the dollar amount and the more complex the transaction, the more attorneys you're going to have involved. The other one I didn't mention is the title attorney or the title examiner. We've heard from Kyle Levsteg this semester, and he is a title attorney. They can do transactions, but generally they're doing large commercial transactions where the buyer has an attorney who's looking out for their interest, making sure they're getting what they're supposed to get from the buyer or from the seller. The seller's got their own counsel that's making sure that they're getting the amount of money they agreed to sell it for. The title attorney is looking to make sure the title matters are all laid out and so that neither side has anything to come back on. And they're usually also working with the lender's counsel to make sure that the lender and their counsel is all happy. But if it's just buying and selling an existing house where Remax put a sign in the yard and somebody came along and bought it, you're probably going to have one attorney that basically handles everything. They'll have to identify we're acting on behalf of the lender. We're not representing either party. If either party wants to have their own representation, you need to go hire your own attorney. But usually, people have realtors who are supposedly going to help them look out for their best interest. But your typical small land or residential house transaction, probably just going to have a general closing attorney down the street to close that. So besides transactional attorneys, we have litigators. They are the sharks. They are the ones that they make movies about and TV shows about. Now, most of them are glamorous criminal defense attorneys or prosecutors like Aaron Reagan, and they glamorize that. It's usually in the criminal litigation side. But most litigators in the real world, for one, they don't do transactions. Some do it all. Fair statement. I know attorneys who close deals and who litigate. I've had closings with one local attorney here, and I've been on the opposite side of him in 2 or 3 different boundary dispute cases or easement dispute cases. But litigators generally have a totally different business model. They have a different schedule management approach because they have calendar calls when the judge calls up all the lawsuits on their whole docket and wants to know where they're at. Where's the attorneys? Are we all ready to go to trial? Where are we at? So litigators can't be pulled into court all the time if they're trying to if they're trying to do real estate closings. So litigators are usually trying to juggle conflicting court dates. Like if they have a calendar call and the judge, in Bartow County and down in Cobb County, they've got a case that's supposed to start at the same time that the judge has ordered them to be over there and give a status report in Bartow County. They got to be 2 places at one time. So litigators have a totally different mindset than most transactional attorneys, copyright attorneys, Medicare attorneys, you name it. Litigators, if they're litigating, they have a different approach. Think about it as like the quarterback as opposed to the defensive lineman. They're both out there, they're both wearing the same jerseys, they're playing for different teams, but they're on the same field in the same ball game, but they have a totally different mindset as to what they're trying to do. The more visible litigators are like personal injury attorneys. We see their ads on TV, we see their billboards going down the roads, their advertisements are everywhere. So most litigators, just like any process, they have experience and or they have a passion, and that builds their confidence and their competence. So litigators tend to find an area that they enjoy working in, or that they're very comfortable in, or that's very profitable, and they stay there. They specialize in it. Just like surveyors may get in the groove of doing strictly topographic surveys for engineering projects, or individual lot surveys for closings, or linear projects for utilities or highway projects. And you typically get comfortable doing that, and even though you're able and capable of doing other work or building your expertise to where you're competent in other fields, we typically find what we're comfortable with and we stay in it. So a lot of litigators will specialize in divorces or DUI defense or personal injury, and that's kind of what they specialize in. The basic skills of litigating, though, are the same regardless of what field they're litigating in. They have to file, a demand letter, a complaint has to be filed, etc. So all those general mechanics are pretty much the same. Besides these who specialize, you do have some attorneys that I call, or they're known as general civil litigators. They'll try any civil case. It doesn't matter if it's contract enforcement, don't matter if it's my coffee at McDonald's was too hot, so I'm filing McDonald's for damages, or my neighbor's cutting down trees on my property. If it can be sued, they'll sue. And what they generally do is they'll build up subject matter expertise or subject matter knowledge about something as it comes up. Like I've sat with lots of attorneys who will say, I've never tried a property case before. How does it normally go? So yeah, sometimes the surveyor is helping the litigator when you think the attorney is supposed to know everything, is supposed to be on the ball. It's not necessarily that they're incompetent. If they took a boundary case and they don't know anything about boundary, they're coming to the land surveyor, who is the subject matter expertise and subject matter source, then they're trying to build their subject matter so that they know how to try the case. It can make a surveyor very nervous to realize that the attorney is leaning almost exclusively on the surveyor for how to try the case, but that's kind of a rare situation. But it does bear saying that attorneys who specialize in real estate litigation are rare, and they're becoming fewer. In the early days of my career, there were a lot more. They were usually all men. Most of them that I can think of that I could name started off as land surveyors. I've worked with 3 particular attorneys, and I know 2 other ones who were land surveyors and then went to law school. And they obviously had subject matter expertise in property and boundary disputes, and so they were really good at it. They've all, for the most part, retired or are retiring, so they're becoming pretty rare. So like I said, a lot of times the land surveyor must assist the litigator in building up subject matter knowledge to help them develop a trial strategy. So when the demand letter went unanswered, or the response was, no, it's our trees, go jump in a lake, when negotiations have failed, then the diplomacy isn't working, it's about to be warfare time, and demand letters did not scare people into settling things, the lawsuit becomes real and is actually a lawsuit when the lawsuit is filed, and the first filing is called a complaint. That's a lengthy legal document prepared by the plaintiff's attorney because they're the one bringing the suit. So there is no defendant without a complaint, so the complaint has to come first. There is no chicken and egg, the chicken came first in this case. It's generally an extension or an evolution of the demand letter, but it has a lot of legal structure. There are legal requirements for what the complaint has to contain, such as who the parties are, what their addresses are. Has to establish that the court has valid jurisdiction. In other words, if it's federal court, you have to demonstrate that it falls within federal jurisdiction. Otherwise, it's a state court case. Has to determine that it's something, you can't file a property dispute case in traffic court. You have to establish this is the proper venue. So The complaint is, the way it works, this complaint is generated by the plaintiff's attorney. They go to Superior Court and file it with the clerk of the court. Then it's put on the docket, and they have to file a copy of this complaint on the defendant. So just like in TV, when somebody serves them with a complaint, they'll say, "You have been served." Sometimes if they know it's coming, if they've been writing demand letters, plaintiff's attorney will simply take a copy of the complaint to the defendant's attorney. And sometimes it can even be done electronically now. But that's how it gets started, is the complaint is filed. Now it has a case number, it's a real case. When it's filed, the clerk assigns it to one of the judges in the circuit. So a judge gets a notification, "Hey, I've got a new case here. Looks like Doe is suing Smith. Dang, let's see what this is all about." So the defendant then has a certain time period, usually 30 days, in which to respond or file a written response. Failing to do so can result in a default judgment. So if John Doe files Mr. Smith with a lawsuit and Smith doesn't respond, he's just basically shrugging his shoulders saying, "Yeah, so what?" The court has to have a winner. They have to have a ruling. So they'll say, "Well, Doe, Smith didn't respond, so I guess he's admitting that you're right, and so we rule in favor of the plaintiff." Poof, end of story. That's usually not what happens, though. Usually a response is filed, and it says, you allege this. Yes, we do live at 123 Maple Street. We admit that. But you allege in count number 2 that we're cutting down your trees. We deny those allegations. Those are our trees. Maybe there's an outlandish claim that says, "Oh, the plaintiff, the defendant has been allowing people to come onto the plaintiff's property and trespass and ride four-wheelers," or whatever. They might simply say, "We don't know if that's true or not. We do not possess enough knowledge to respond to count number 3. So similar to how the complaint lays out the groundwork for the plaintiff's case, the response is supposed to address all those, but in reality, sometimes they really don't respond fully because they're still trying to figure out how they're going to defend the case. Once the lawsuit has been filed and a response has been filed, and by the way, I'm gonna say this: if you're involved or brought into a lawsuit, my strong recommendation is that you ask for, you demand, and you get and read the complaint and at least the first response. Now there's going to be amended complaints, supplemental filings. Those you probably want to read too, depending on your role in the case. But I started this policy a few years ago because I got blindsided on the stand in court when somebody asked me about something that I hadn't even heard of yet. And it was like the 4th count in the complaint. And my client's attorney was a little bit negligent, I guess, or a little bit dumb, and just had not really even looked to respond to that aspect. And it was involving an easement. And I think my client's attorney just wasn't comfortable with it, didn't really understand it, so they just kind of ignored it, which is not good practice, but that was still part of the complaint, and it hadn't really been responded to. So the other side jumped on it and jumped on me, and I didn't know it was part of the case. So I said, from now on, I'm reading the complaint, the response, because you don't want to be, if your client's response, say your client is the defendant, they filed a response that says, "No, those are our trees. That fence has nothing to do with the property line." And then you determine, no, that fence is the property line. Your client's attorney needs to know that your testimony is going to contradict a response that they entered into the court. Doesn't mean that you don't testify to it. Doesn't change that the fence is the property line or the fence is 1 foot from the property line or whatever. But you've got to communicate with your client's attorney that, hey, something that you responded to is not true. Because I've done basically that same thing where I said, "Oh no, the fence is right there on the property line." Really, are you aware that your client responded that he thinks it's at least 20 feet from the property line? No, I didn't know that. Oh yeah, it's in the response. Count 7. So You need to know all these things and read the complaint and the response. Usually what happens then is the judge says, okay, y'all got 6 months to run discovery. 7 months from now, we'll have some hearings on preliminary motions. 8 months from now, the trial is going to start. They'll go ahead and put it on their calendar so that they're managing the court's schedule and time. So this is where surveyors get a lot of involvement. It's the discovery period. So a lot of times, part of the discovery is called interrogatories. This is where one side sends the other a list of questions or demands. Give me all copies of your mortgage documents. I actually saw this in a case in Ansley Park in downtown Atlanta, where one side was claiming that the other side was encroaching and then it was overlapping all this problem, but they had just filed a mortgage where they said there were no boundary problems that they were aware of. So their written statements to their mortgage company contradicted what they put in the complaint. And they quickly resolved that case because that person had to apologize, withdraw the case. I think they even had to pay a little bit of money because they found during discovery, and the other side's attorney was just real smart. I would not have thought to do that, but they said, oh, they just refinanced 6 months ago. When did y'all start fighting over this? 15 months ago? Huh. They had done enough transactional law to know that that disclosure and statement was required for the mortgage company to release the money. So they had them. So discovery period is when you discover things. You discover all you can about the other side's case. You try to get everything out in the open. In this case, the plaintiff, had to answer discovery and provide these mortgage applications. That's when they realized, uh-oh, we've stepped in it. Let's start talking settlement. Let's start talking drop the case. And it never went any further. In trying to find out what the other side's got so that you can better formulate your case or withdraw or figure out, wow, the other side's really wrong. We've got a great case. We're not going to settle till we get everything we want. It's all part of trial strategy and just making balanced decisions for the case, for the parties. And these discovery requests usually carry the same weight as a subpoena. So, subpoena is a court-ordered piece of paper that says you have to do this. You have to appear. You have to produce your file. You have to do this or that. You can have a subpoena for a drug test, in certain criminal proceedings or negligence or personal injury cases. So you have to answer this truthfully, because if it comes up in court that you didn't, or you lied and said I had never done that, and then later they find where you did, it basically carries something similar to a perjury penalty. The most common thing during deposition or during discovery for surveyors are called depositions. So during both sides, or during discovery, both sides try to find out what the other side's got. We just went over that. Both sides can talk to their clients and their clients' witnesses and know what they're going to say and ask them questions, and they know what they're going to come out with. What they don't know is what the other side's going to say or what the other side's witnesses are going to come out with. So they'll serve a subpoena for deposition, where the witness has to come to usually the other side's attorney that's filing it. Filing the subpoena. It usually has to go to their office and give testimony. So deposition is a lot like courtroom testimony, except there's no judge, there's no jury, usually no audience, or at least very small. Usually you'll have both sides' attorneys there, you'll have a court reporter there to take down the testimony, to make it legal, make it admissible. And usually the other side's attorney asks all the questions. If you're the one giving the deposition, your client's attorney is just going to sit there and not ask anything because they don't want anything more than is necessary put on the record. So this deposition transcript is generated by the court reporter. The witness is usually allowed an opportunity to look over it, to point out any mistakes. They cannot, however, change their testimony. They can't go back in and say, oh, I meant to say this. No, it's just in regards to what was said. For example, if they said my presence was required, well, that's presence. But if the court reporter take it down as presents, like my Christmas presents, that can mean something totally different. So in that instance, it would be a spelling errata. You can go through each line and say this word should be this word, this phrase should be this phrase. And it's usually like homonyms and things that sound alike but mean different things. Once you've gone through the discovery period, both sides will at least think about doing a motion for summary judgment. The attorneys will call this an MSJ. So what this basically is where whichever side does it, often it's both, says, my case, Your Honor, is so good. We have established every fact that we needed. There's no way that the other side can have anything to rebut my evidence. It's clear that I'm right. It's clear that my side is going to win. And it's in the court's best interest just to give summary judgment, just to give overall, party A wins, party B loses, end of story, no jury, no testimony, no further court resources are necessary. I have won the case. You can see by all this information that I've just filed in my motion. If the case really is one-sided, or if the other side didn't really participate very much and put up much of a fuss, it's not uncommon for a judge to grant summary judgment. And it may be for the defendant, it may be for the plaintiff. But if it's just that cut and dry, like, oh, what are we doing here? How do we get here? Yeah, this is not a good case. Then the judge will usually see through it. If the moving attorney makes a good enough case, they'll realize, oh, well, there's really, I don't want to sit through this. I can see he's right. If, for example, the plaintiff files a motion for summary judgment, the defendant can still file a response to that motion. Say, Your Honor, they're wrong. We have a great defense. Here's our defense. What's more common is that the defense might file their own motion for summary judgment and say, Your Honor, the plaintiff's case is so weak. We don't, they're abusing the judicial system. This is a frivolous lawsuit. You should throw this out. You should rule in our favor and throw this out now before it goes any further. So they both make this same kind of claim, and if it's really one-sided, if it's really just cut and dry and really lopsided case, the judge will rule accordingly because they don't want to sit there and hear a case that's a waste of their time. But if it's not that cut and dry, we're going to court. Now, in the land surveying world, the subject matter is usually so complicated compared to other subject matter in criminal cases where it's more easily understood, that it's very common for a judge, if they don't have their own special knowledge about the subject matter, to appoint a special master to hear the case for them. It's like a substitute teacher. It's a substitute judge. Special master is an attorney, usually in that circuit, but not always, who has subject matter knowledge that the judge lacks. For example, if the judge is a real estate attorney and that's their expertise, but the case is over medical malpractice, when the judge might say, I don't understand medical malpractice, I'm afraid I'll make a bad ruling. So they'll find an attorney who does have specialty experience in medical malpractice, and they'll appoint them as the special master. Now, the special master usually has all the same rights and privileges as the judge as far as making rulings on motions and orders, dictating discovery. They will conduct a hearing just like a regular trial that a judge would conduct. But in a civil case, it may be done in a law office or a library. It's not necessarily going to be held in a courtroom. It's not necessarily going to be court security or a bailiff. This is a civil matter over property. As long as everybody agrees to where it's being held, the special master can hold the hearing wherever. At the end of the special master hearing, the special master issues a report and sends it to the superior court judge that appointed him or her. And usually what happens is the superior court judge will rule and just adopt the special master's report. If the judge has some reason to disagree with the special master, which is rare if you think about how you got there, then they're almost always going to adopt the special master's report. It can still be appealed, just like a regular Superior Court judge ruling, but that's where it goes, and that's how special master hearings go. And most property cases go through a special master. I'd say around or slightly more than half. Now, for a surveyor, you need to understand that there's two kinds of witnesses. There's a fact witness and an expert witness. A fact witness knows some facts. They saw a hit and run. They were there when they cut down the tree. They saw the surveyor drive a stake in the ground. They're testifying as to a fact. They cannot express any opinion. For example, they can say, I saw the plaintiff climb over the fence and cut down an oak tree on December 8th, 2017. That's a fact. They can testify to that if they were actually there and saw it. But they cannot express their own opinions or make statements like, he cut the tree down just to spite my dad. Well, that's an opinion. He can't say that. That's not a fact. That's an opinion. So the other, if that was to happen, the other side's attorney would object, and the judge would sustain the objection, and that would be stricken from the record, and the witness would be admonished not to make opinions. For a witness to be recognized or admitted as an expert, a foundation must be laid, and an expert can express opinion. So the expertise that's required is usually relevant experience, training, education. The way it happens is, if you're called as an expert witness, the judge brings you to the stand. You raise your right hand, swear to tell the truth, the whole truth, nothing but the truth. And then the attorney that called you begins by saying, Mr. Chastain, please state your full name. What do you do for a living? How long have you done that? Do you have any special education that prepared you for a career in land surveying? Oh, what degree do you have? Where did you get it? How long have you been surveying? Are you licensed in the state of Georgia as a land surveyor? Approximately how many surveys have you conducted? Once they have asked the questions that would qualify a surveyor as an expert witness surveyor, then they'll say, Your Honor, I move that Mr. Chastain be admitted as an expert witness in the field of land surveying. The other party can, if they don't like it, say, well, don't other surveyors have more experience than you, or don't most surveyors have a better degree than you do? It's not common, but the other side, if they don't want the surveyor testifying, they'll try to knock him down, or they'll try to limit. Maybe he can't speak to easements only to property lines, or only to the property line that he surveyed. We don't want him giving testimony about the broader field of surveying or how surveyors make decisions. We want his testimony as an expert to be limited strictly to the survey that he did for John Doe in 2021. And the judge can do that. It comes back and forth. And the expert is limited to whatever field they're admitted to. So a land surveyor can't start giving expert opinions about computer algorithms or about the COVID virus. It has to be about land surveying and or whatever focus that the judge put on them as a qualified expert. So expert testimony is opinion. Usually it's not just facts. Facts might be, yes, I prepared a survey for John Doe. Yes, I set a corner. Such and such. Those are fact questions, but generally they're going to want to know why you set that pin there, why you determined that was the property line. They want you to possess or to express professional opinions. It might be something like, in my opinion, the iron pin called for in the 1937 deed is the same iron pin that I found in the root ball of the 48-inch hickory tree. Or, I believe the distance in the deed of 450 feet is incorrect because the fence line itself intersects the stream at around 540 feet. So I believe the record distance has a transposed number in it. That's all opinion. That's all really speculation that would otherwise be inadmissible. But as an expert in this field, the surveyor can express opinions that help the court to make these decisions. But just like we've already learned in the board rules on testimony and statements, land surveyors must be objective in their testimony. Our testimony must be grounded on facts and solid professional opinions and doctrines. We can't go off the reservation and make up crazy ideas. We can't claim to support bad decisions with some outlandish theory. We've got to be able to point to textbooks and other court cases, things that we've learned in school and been taught as to why we did this. So, surveyors and any expert witness have to be mindful to be objective and truthful and independent. That's the ability to testify as an expert witness is a privilege that the court grants. It doesn't grant it just to anybody who has the credentials. It's granted so that whatever testimony the expert brings, the expert is basically becomes a trusted friend of the court. When you're on the stand as an expert witness, you're not really either side's attorney or either side's witness. It's like you're the judge's witness. The judge is wanting you to give independent, factual testimony that can help him or her and the jury, if there's a jury, in making the right decision. If you, as an expert witness, look like you're really favoring your client's side, you're really trying to overlook things, you're really trying to say, yeah, the deed said this, but I think it's over here. If it looks like you're trying to advocate or trying to twist or trying to be on one side or the other's side, then you can be disqualified as an expert. The judge can dismiss you right then and say you're dismissed and your testimony is stricken from the record. And I've heard of this. I've not saw it firsthand, but I know of a situation where the surveyor's testimony was deemed very partial and the judge dismissed him. Well, you're at trial. You're already past the discovery period. The other side didn't have time to go get another expert witness surveyor. Their case was crushed because the surveyor, trying to help them, trying to make their side look like the right side, trying to convince the jury to agree with their client's attorney. But he became partial. He became obviously slanted and not independent. And once that happened, the judge had to declare him as no longer an expert witness, but a prejudiced witness, and struck his testimony. Without his testimony, his side lost a good case. They had the winning side, but they lost the case because the expert crossed the line and was not factual and objective. I don't know if they ever did, but I heard they were considering going after the surveyor for some of their damages. They lost over $100,000 in the lawsuit. They determined it was because the surveyor did a bad job of testifying. My understanding was that the surveyor was probably going to try to pay him $50,000 and kind of split the middle, settle in the middle, and instead of going to court or instead of having to pay out the full $100,000 plus attorney's fees. So you've got to be objective and independent, or bad things can happen. So it's really important that you communicate with your client, but more so your client's attorney, and say, this is what I'm going to say. And they will try to say, no, don't say that, or don't say it like this. Well, maybe there's nothing wrong in rewording something and making the attorney happy. That may be fine. But you're the owner of your testimony, not the attorney. The attorney's there to win a case. They should know better than to try to get you impeached as a partial or advocating witness. But they may ask you to do things that you should not do because they want it done that way to help their case. But you have to remain objective and fair and independent, regardless of who's paying the bill. Now we'll wrap it up by saying that all cases eventually come to an end. The most common way is through a settlement. This is where both sides are like, yeah, we don't really want to go to court. We're just going to lose. It's going to cost another $10,000 to go to court. We might lose. Would you settle for $20,000? Hey, would you do 25? Well, I might. Yeah. Will you do 20 and put the fence back up? Yeah, we'll put the fence back up. That's fine. So they usually settle on something, and then they tell the judge, we've settled the case, we're withdrawing it. The judge is very happy because that's one less trial on his calendar. The other ways that courts can end is through a decision or a ruling. Means the same thing. Where the jury comes back with a verdict, or if there is no jury, sometimes these cases are held or heard strictly by a judge who sits there and listens to both sides and makes a ruling, just kind of like the TV judges. They make the ruling without a jury, and that's called a bench trial. That's just when it's the ruling comes from the judge's bench rather than the jury panel. And besides a motion for summary judgment, which we talked about, we briefly talked on default judgments, where one side becomes inactive in the case. They quit responding. They quit making their deadlines. They quit meeting their obligation for the production of evidence or witnesses. So basically, they've given up. So the judge will make a ruling that the other side wins because the losing side quit fighting. They quit putting up a case. And when a decision is handed down, both parties have a statutory time period to file an appeal. The appeals court does not have to take up every case. They can say, we've looked it over and we agree with the lower court. And there's often some follow-up work for surveyors at the end of a court case. The court may rule that an existing survey is to be revised to move the line over here 10 feet or hold this rock instead of this pin. Or they may say that a new survey should be made that connects points A, B, C, and D. That may be part of the ruling, and so the case is not truly over until the surveyor makes the new case or makes the new plat, which closes the case. Those are boundary cases. There are lots of different kinds of cases. There are easement rights. There are view shed obstruction rights. There are nuisance cases where someone's doing something, playing music or shooting a gun too close to the property line. There are issues in title where Jimmy had 3 boys and they were all supposed to get a third of the property, and now one of them's come back saying he didn't sign the deed, and where's the third of the property that's his? I testified in a case one time where a loading ramp was alleged to be steeper than building code allowed it to be. This was a federal case because an international hauler had backed his tractor trailer into this loading ramp, and then his brakes gave way. The guy got run over and hurt, didn't get killed, and they blamed it on the loading ramp being too steep. So we surveyed it, determined the actual slope. I was questioned on how did I determine that? Could I establish the math? How did I determine that it was this percent slope instead of this percent slope? The plans say it's this percent slope. Mr. Chastain, are you saying that the plans are wrong? That sort of thing. There's lots of different things. Like I said, also been involved in professional negligence, where they are alleging that a surveyor has done something bad that drops below the standard of care and is negligent. So there's lots of different kinds of cases. This is just an overview into how the court system works, so that if you face this in your professional career without any other additional training or education about litigation, you at least know how the pieces fit and how you should probably try to conduct yourself. Thank you.